next presentation is Dr. Jenny Gibbons, the Deputy Head of York. Hi, Jen. The Deputy Head of York Law School at the University of York in the UK. And Dr. Gibbons is going to speak about research magpies and shiny, unofficial knowledge in legal education.
Hello, my name's Jenny Gibbons, and I'm talking today about my research into research magpies and shiny unofficial knowledge in legal education, which I'm hoping at the end of this will make a bit more sense than it probably does now. I am the Deputy Head of York Law School in the UK. My doctorate is in education rather than law, so I have a very strong interest in legal pedagogy and design, which is why I'm very pleased to be presenting at this conference today. For those of you who don't know, York Law School is a relatively new law school at a well-established university. We have been open for just over 10 years and we have a very distinctive curriculum that is designed around problem-based learning. So the photo here shows our purpose-built study centre where all of the classrooms are designed to facilitate small group sessions who do all of their learning through guided discovery model problem-based learning, which I'm happy to talk about with anyone who's interested, but that's not the subject of my session today. Instead, I want to talk about a particular area of research that I conducted with a couple of my colleagues, and the details of the paper are on the bibliography at the end of these slides. And the reason that we conducted this research is because although we are big fans of training students into conducting independent research, we were very concerned about what they were actually doing. So one of the things that we notice when students submit their essays is that their referencing indicates that perhaps they aren't looking at the same kind of sources that we think they are. So we just have this ongoing concern about what the students are actually doing when we ask them to conduct independent research. So my colleague conducted recordings of a sample of 10 undergraduate students undertaking a research task. So the task was designed specifically for this study, and the students had a whole ethical approval for this and knew that they were going to be recorded in this way. So effectively, we recorded their screen and their narrative on how they were undertaking the research for this particular task. The links to the recordings are available in the paper, so you can actually go and listen in, and there's kind of a transcript of the students talking whilst the screen shows them undertaking their research. Now, the task was one that is very typical of the kind of thing that we'd be expecting our students to do at the law school, and that was effectively finding the answer to two questions. The first, on what basis can the UK courts lawfully restrict freedom of speech? And the second, are protections for freedom of speech in the UK sufficient? So an interesting and obviously topical issue that all of us discuss with our law students around the world. And I say on this task, for the first one, this is kind of a very substantive question. We'd be expecting them to look into freedom of expression as a human right, have some kind of understanding of the Human Rights Act 1998 and its impact in the UK, and also this idea of what the court's role is in the balancing of rights. So quite a kind of distinct task, but a lot of information there for them to be finding. For the second one, this is more of a normative question, and for this we would expect them to be engaging with the academic authority, and because we have quite a lot of international students, there'd be an element there of some kind of comparative research would be appropriate as well. So of course we have an expectation of what the students should be doing, and in the curriculum, when we're looking at freedom of speech, we'd also be providing kind of structured resources and reading lists and lectures. So there'd be a lot of kind of structure there, but we are still interested in this independent research, and this activity was to try and kind of really get to grips with what they were actually doing, rather than perhaps what our expectations of them are. So this is all set out in the paper. I'm just kind of giving a brief summary to this. But effectively, we quite like this idea of seeing students as magpies, so the kind of birds that kind of just go out and find the shiny things and bring them back to their nest. I appreciate that's a very kind of clunky metaphor, but we find it quite useful to see what they're doing. So this idea that they are, trying to use their time as efficiently as possible to find the shiny knowledge that will enable them to come back to the classroom and effectively showcase that they have found the answer to the task that has been set. However, but under this study, we realised that things are not quite as they seem, and we were quite concerned actually, particularly knowing that the students knew that we were watching what they were doing, in that they really didn't seem to engage with the kind of official knowledge resources in the way perhaps that we would expect them to do or that we intended them to do. So a lot of them, for example, just bypassed the information that we had provided for them, they were going to kind of more unofficial sources. So this idea of official knowledge and unofficial knowledge I'll come back to in a moment. But the main findings from the survey is that they weren't doing what we were expecting them to do. And we found that there was a bit of a tension between encouraging independent learning, which is very much part of the problem-based learning model, and yet when we want them to be doing that, we then query and question the kind of information and the sources that they're using, this kind of unofficial knowledge. And another thing that we identified was that there was quite a difference in the time spent, or the time kind of they explained to us that they would spend on the substantive versus the normative sources. So they seemed relatively familiar with the fact they would need to be looking at the legislation and relevant cases, for example, and even the kind of differences between the domestic courts and the European courts around this issue. But for the second part of the task, this kind of, is it good enough kind of question, they really didn't spend a huge amount of time on that. And they didn't seem to really appreciate the value of the normative sources sufficiently. And obviously in an academic subject like law, we found that quite problematic. So just to flesh out a little bit these kind of terms, and this is where I'm moving more into my area of research rather than an explanation of our programme. And this is these ideas of official knowledge, charismatic authority, and this new idea that I've been developing and I'm interested in finding your views on, which is this idea of unofficial knowledge. So in terms of official knowledge, this kind of builds on the work of Apple from the 1990s, who was looking at the school curriculum, and Bernstein as well, who also had an interest in, what does the school curriculum, how do we kind of classify the knowledge and frame the knowledge? So what knowledge is relevant to different disciplines, and how do students understand that knowledge in the way that they do things? And I've been interested in this quite a long time. This is the basis of my PhD, is thinking what some of these ideas mean for the law school curriculum. So in terms of official knowledge and how it relates to law, things like reading lists, signposting cases, instruction-led activities, lecture sites and so on, all classify to the students what we believe is the knowledge that is relevant to the discipline. And also the way that we present that, and particularly around kind of assessments, we kind of frame for them what knowledge we regard as important, and we want them to effectively showing back to us. And so there's a kind of authority around the law school that gives legitimacy to the knowledge that we present as being the curriculum. I'm kind of going over a huge amount of work in this kind of brief summary, but essentially these ideas of official knowledge are quite well established, and in law they very much link to, for example, the qualifying law degree, the kind of things that the professional regulators tell us that we should be telling our students. The concept of charismatic authority is one that you may be familiar and it's the concept of leadership . involves a type of organisation or a type of leadership in which authority derives from the charisma of the leader. And this stands in contrast to two other types of authority, being legal authority and traditional authority. And just to let you know, I took that definition, cut and paste from Wikipedia. And my issue here is that's exactly what the students do. That Wikipedia and Google sources have themselves charismatic authority, and the students use their research to find these kind of shiny things that are very easily accessible and that they can bring back and kind of show that it has charismatic authority. So this third element of unofficial knowledge is a concept that I've been developing in my work. And it's effectively building on this idea of, can we regard Google as having charismatic authority, and what does that actually mean for the way that we classify and frame the knowledge in our curriculum? So this idea of weakly classified information has an impact on what the students actually learn and what their perception of law actually is. And following on from our study, that is something that we find quite problematic. So in the task that we set them relating to freedom of speech, if they had just used online search engines to find their answers, what answers would they be finding? And, when I did this for myself, just using kind of random search terms, or even what the students do, which is just take the whole question and put it in the search bar, what do they actually find out? And it was quite interesting in different search engines. It's very American focused. Well, that's one thing. So when we're kind of looking at the UK Constitution and UK human rights, you have to kind of wade through a lot of American sources. But also, of course, the algorithms that you have created on your own computer will also dictate the kind of information that you find. And I think all of those are problematic elements. Which leads me on to where I want to bring you into this debate on this idea of discussion points, because this is something that I intend to do additional research on. And I really want kind of validation as to whether this is an area that needs research and some ideas about how to conduct it. So in terms of the last 5 minutes of this presentation, this session, I'd really like to kind of get your ideas on these two discussion points. So first of all, thinking about the power bases, what are the influences that actually determine what unofficial knowledge looks like, and does that create echo chambers? Will that actually change what people think some of these key legal concepts and principles mean? And what impact does that have on us in the institution? And secondly, is this something that needs greater theoretical underpinning? Is there scope for this to kind of join these ideas of charismatic authority with this idea of official and unofficial knowledge? And I can see that it has resonance in law, but what does that mean for other disciplines? And also kind of law as taught in other areas. So I'm going to stop talking at this point, and I'm hoping that this will be the point that people can join me in these conversations. Thank you.
Thank you, Jen. And we do have, so there's a great presentation, of course, and we've got one question from George from the Access to Justice group, who spoke earlier in the afternoon. And George asks, if students are using charismatic information anyway, would you encourage students to contribute to this type of information through editing wiki pages, for example?
Hi, I found that a very disconcerting thing of watching my own presentation. I think that's the first time I've done that, so that was rather discombobulating. That's a really interesting point about this, picking up this charismatic authority, charismatic information point, and it links up with some of the former presentations about things like the Wiki Jurist project and kind of open access, open curated materials. And I think they are very useful. However, I do think that we need to be thinking about the power bases of the curation. Who is responsible for putting the boundaries around that knowledge? So I absolutely think that the student voice should be in there, but who ultimately gets to decide on that? And who has the legitimate authority to be that curator, to be the person who is setting the boundaries on knowledge? And I'm finding the kind of Google you know, at the moment it is Google or the kind of, you know, the people in Google who have these kind of abilities to kind of do it, but they're doing it in a very light touch way. And I don't have the answer to that. And I think it's really important to have this student as producer, but it does lead to these questions about what does that actually mean for the knowledge itself.
I've got two questions. Just to follow up. I mean, presumably the only way you could know, you'd have to ask Google, I guess. Would you? About how, you know.
Well, this is Google itself is a very kind of opaque organization. You know, how do we know where they draw the line as to what is okay and what is not? And my concern is there's a huge amount of misinformation, bad scholarship, bad knowledge on the internet. And for a young, you know, student who is very familiar with just kind of looking for the answer on the internet, and I think for school education, that's an efficient way to spend their time. But once we get into what we're doing, which was we're trying to create critical thinkers and people who are going to generate new knowledge, if the foundational base that everyone is working on is so unstable, what does that actually mean for future knowledge? So can we trust Google to be the people to do that? I haven't got an alternative, but I'm just saying that we need to be kind of mindful of the kind of very unstable foundation of knowledge that is being used in this way.
Thank you. And then Natasha comments that she considers unofficial knowledge as being information from unverified resources. So she thinks there's a danger of echoing inaccurate information. I suppose the idea is, you know, the student finds this inaccurate information, uses it as a kind of feedback loop. I guess that's the idea, Natasha. Natasha's question is it so much about the charismatic nature of Google, or is it just more about convenience and speed of using Google or Wikipedia?
Picking up on that kind of verified and unverified sources, I think it also goes then to whether we believe that a verified source is therefore the truth. And in the current debate that's happening around the world, you know, there's a lot about whose truth are we talking about here. My subject that I teach the most is I teach constitutional law and I teach human rights law. And they are two kind of subject areas where the established textbooks tell a particular version of the historical truth. And the conversations I have with the students is, well, there's another version of truth. And some of the voices haven't been heard in the official versions of knowledge. So I do think there's a space for unofficial knowledge to effectively challenge the official knowledge and say, actually, what you're saying is just one version of the truth. And so if we make that distinction between the textbooks being right and Google being wrong, I think that's too simplistic, because actually the textbooks themselves are a convenient version of a simplified truth that tells a particular voice and a particular narrative. And for, you know, UK constitutional law, that has some very dodgy, you know, questionable sources that I think are now very much part of the debate. So I think the students should be involved in that debate. But I just, you know, it goes back to this power and curation. Who can be trusted to you know, draw the lines between what should be taught and what shouldn't be taught?
I think that ties what you've just said ties into the question from my colleague Professor Sarabi Chopra, who says that research is increasingly highlighting the hierarchies, gender, race, class, encoded into widely used technologies. Perhaps we need to be reflecting on this critically in legal research teaching in year one, rather than simply introducing students to different tools and databases.
I absolutely agree. And I think in legal education, doctrinal research has a very strong presence throughout the curriculum. Whereas, you know, when we're talking about legal research, that is just one version of research. And it usually takes till later on in the syllabus that students learn about, say, critical research methods or feminist or socio-legal. But actually, if you're using a different research method, you find a different version of the truth. So, you know, absolutely, we need to be teaching doctrinal research. So, you know, this is how you find the statute, this is how you look at a case, this is how you analyze a case. But if you're analysing a case from kind of 30, 40, 50 years ago, I don't think you should ever discount the culture that was, you know, influencing the judges. So I don't think that can be held as a truth. It's, you know, it is a point in time when we're looking at case law. And if you actually introduce them to kind of critical method, feminist method, then those kind of critical voices come into their heads when they are doing doctrinal case analysis. And I mean, colleagues and I may disagree on this, but, you know, I think that is as important as discussion as kind of looking at what one judge said versus what another judge said, when both of those judges are dead and both of those judges came from a particular, you know, demographic at a particular time. So, you know, all of that, I think we need to be discussing more about what doctrinal research means and bringing in different research methods as part of legal research training.
Thanks, Jen. A comment and then two more questions. So one comment first of all from George Shinrock-Ho from the Access to Justice group earlier. He just comments that it's inevitable that students who are sort of short on time and under pressure have got to rely on these unofficial sites. Then from Heidi says, I'm an academic librarian with a background in law, and the current conversation has a lot of overlap with the threshold concept in information literacy of authority as constructed and contextual.
Yes, I am familiar with the threshold concept idea, and I think it's really valid and important. I'd have to dig around in my head to make the connections with what I was doing here, but I'm perfectly...
The threshold concept of authority, I think, is the...
Yeah, absolutely. But I would be really interested in developing that as a kind of overlapping idea for study in the future with anyone who's interested.
Angel from Clear says, who spoke earlier, Angel says she completely agrees with you that the issue of whose truth it is and student autonomy in deciding some part of the course content can highly enhance student engagement and ownership during the knowledge creation process.
Yes, and I think we it's a courtesy to our student body to recognise that they have a different truth. And, you know, when we have international students coming to the UK from all over the world, even the reason why they're speaking English and they're coming to the UK is linked with this idea of a version of the truth. And so I think we need to recognise that those voices are absolutely valid and facilitate the ability to be critical about when we are looking at what the law actually is and what the law states. So, you know, I think there is something static there. You know, obviously official knowledge, there's many things that are true and valid, and obviously the law as it currently is, it has to be seen as static. However, as soon as you get into the law as, you know, as a historical narrative, you get into different versions. And also if you see the law as a comparative, and, you know, for example, human rights is an area, we have to be looking at the law as it applies in different countries. And then you get further away from this version of official knowledge. And so we then need to be thinking about, well, if we're looking for counter to that, kind of critique of that, how valid is that information? You know, who is that authority? And I completely support students in looking at information from NGOs and from, you know, it doesn't always have to be a kind of twice peer-reviewed article for it to be a valid source of information. But then it all starts to get a bit weaker and whatever, and we start questioning where this authority comes from.
Jen, there's a comment I'll just pass on from Jaspal Kaur, and I think the comment is that about the validity and authority of unofficial knowledge, and his point is that this knowledge might help in contextualizing the research as a backgrounder. So I think he was saying it's kind of a preparation, unofficial knowledge as a preparation for engaging with official knowledge, and so some kind of hierarchy of reliable resources. Jen, and thank you, Jaspal.